Good evening. Welcome to all who are in the room and all who are watching on live stream. This is the second event of our Centennial and our inaugural Centennial speaker, and I have the great honor of introducing him. Oh, I probably should have said I'm Michael Hunter Schwartz and I'm the Dean of McGeorge. Erwin Chemerinsky became the 13th Dean of Berkeley Law on July 1st, 2017, when he joined the faculty as the Jesse H. Chopra Distinguished Professor of Law. Prior to assuming this position from 2008 to 2017, which is a long time to be a dean. He was the founding dean and distinguished professor of law and Raymond Pierk Professor of First Amendment Law at the University of California, Irvine School of Law. Before that, he was the Alston and Bird Professor of Law and Political Science at Duke University from 2004 to 2008, and from 1983 to 2004 was a professor at the University of Southern California Law School, including as the Sidney M. Ermas Professor of Public Interest Law, Legal Ethics, and Political Science. From 1980 to 1983, he was an assistant professor at DePaul College of Law. He is the author of 19 books, including leading case books and treatises about constitutional law, criminal procedure, and federal jurisdiction. His most recent works are Worse Than Nothing, The Dangerous Fallacy of Originalism, 2022, and Presumed Guilty, How the Supreme Court Empowered the Police and Subverted Civil Rights, 2021. He is also the author of more than 200 law review articles. He's a contributing writer for the opinion section of the Los Angeles Times, and he regularly writes for our own SAC-B. He also writes for the ABA Journal and the Daily Journal and frequent op-eds in newspapers across the country. He argues appellate cases, including in the United States Supreme Court. In 2016, he was named a Fellow of the American Academy of Arts and Science. In 2024, National Jurist Magazine again named him the single most influential person in legal education in the United States. In 2022, he was the president of the American Association of Law Schools. He received his BS at Northwestern and his JD from Harvard. What you may not know about him is two things. He has a huge connection to McGeorge because he came here for years, for those who are alums, you know this, to teach Bar Bree as part of your bar review course. I see nodding heads from alumni that remember him teaching your bar review constitutional law. And the second thing that I think many of us in legal education know, but I'm not sure that you all would know, is that he has got a reputation for being one of the kindest, most humble, gentle souls. And so the reason why he is so successful is because sometimes good people really end up doing really good things. Please join me in welcoming him. So proud.
Thank you so very much for that kind, sweet introduction. It is very familiar for me to be standing here. Many years I did the Bar Bree lecture in this very room. No democracy lasts forever. Democracies are there until they're not. We can all think of countries around the world that were democracies, but are no longer democracies. I never imagined that I would fear for the future of American democracy. But I can tell you, as this new year came, I've never felt so much trepidation for the future of this country. Certainly we could point to January 6th and the insurrection as unprecedented in American history. But my concerns transcend that day or even an individual who might be president. What I want to suggest to you today is 4 points. First, there is a crisis facing American democracy. Second, in part it stems from choices that were made in drafting the Constitution in 1787 that have become particularly salient in recent years. Third, in part the crisis stems from choices that the Supreme Court has made in recent years. And fourth, I want to suggest there is hope for the future. The flaws in government can be fixed if there's the will to do so. So to begin, why do I have such fear for the future of American government? Why do I believe that there is a crisis? To start with, it's that the American people have lost faith in American government. In 1964, a poll was done, and 77% of those surveyed expressed confidence in American government. A similar poll with the same question was done in September of 2023. Only 20% of those surveyed expressed confidence in American government. In that poll, only 4% of those surveyed said that they thought that American government was working well. Similarly, if you look at the confidence levels in the branches of American government, they're at all-time lows. We have the second successive president where approval ratings hover in the low 30s. The Supreme Court now has its lowest approval rating in American history. A Quinnipiac University poll last June had only 30% expressing approval in the Supreme Court's performance and 59% expressing disapproval. A Gallup poll had only 25% of those surveyed expressing confidence in the Supreme Court. The approval rating for Congress is 18, and that might be 18 people, not 18%. At the same time, polarization in our society is greater than it has been at any time since Reconstruction. There are many different measures that political scientists use for polarization. One of them is to compare the approval and disapproval ratings for a president. So, for example, when Donald Trump was president, his approval rating among Republicans was 87%, and his approval rating for Democrats was 6%. That's the largest difference ever since this has been measured. The second largest difference is for the current president, Joe Biden. 78% of Democrats expressed approval, whereas only 12% of Republicans expressed disapproval. One of the most discouraging statistics I found was of voters who were between 18 and 30. 55% in this survey said that they believe that American democracy is failing. Even worse, 29% in this survey said that they thought it would make no difference whether the United States was a democracy or a dictatorship. And another 19% in this survey said that they thought a dictatorship would be a preferable form of government under many circumstances. There are surveys that are done, rankings that are done about democracies in the world. Similarly, there are surveys, ratings that are done about democracies that are in danger. The United States doesn't come at the top of any list in measuring democracy, but it is among the democracies that's regarded by experts in the field as in danger. If you'll accept my sense that all of this reflects a crisis in our government, then we can talk about why. As I said, I think in part it stems from choices that were made in ratifying the Constitution. Let me be clear, I think that many of these choices were necessary in order to have the Constitution accepted at the Convention in Philadelphia in 1787 and then ratified by the state conventions. But I think many of these were Faustian bargains. Let me point to 4 flaws in the Constitution and then explain why I think they've become particularly important now and are contributing to the crisis of democracy. The first is using the Electoral College to choose the president. I think the Electoral College was a terrible way of choosing the president from the outset. It was clearly based on distrust of the people. In fact, Alexander Hamilton in the Federalist Papers expressed the idea that elites who are informed should be choosing the president, not the masses. Early in American history, it was state legislatures that chose the electors. There wasn't even popular votes that mattered. There's something even worse about the Electoral College that's often overlooked. It was created in part because of the institution of slavery. Southern states knew that their enslaved population would not count for them politically, not count in terms of representation in Congress, not count with regard to choosing the president. And a compromise was reached where enslaved individuals would count as 3/5 of a person and determining the number of seats that a state would get in the House of Representatives. This meant that slave states would get some political benefit from their enslaved population, even though, of course, these individuals could not vote. As you know, a state's representation in the Electoral College is the sum of its senators and representatives. So southern states would benefit from choosing this president this way because their enslaved population would count towards the number of electors they got. This isn't something that's just realized in hindsight. At the Constitutional Convention in 1787, Hugh Williamson, a delegate from North Carolina, praised the Electoral College because it would benefit North Carolina and other states with enslaved populations. None other than James Madison from Virginia praised it on the same grounds. The greatest flaw, of course, with the Electoral College is when it produces a president who's lost the popular vote. It's impossible to reconcile that with even the most basic sense of democracy. Can't think of any other country in the world that would use a popular election for president, but they have the loser then named the head of the government. At no time during the 20th century did the loser of the popular vote become president because of the Electoral College. So the Electoral College through the 20th century was academic interest. But twice in this century, and almost 2 other times, the loser of the popular vote became president. As you know, in 2000, George W. Bush lost the popular vote, but became president because of the Electoral College. And in 2016, Donald Trump lost the popular vote by 3 million votes, but nonetheless became president. And it almost happened in 2004. If John Kerry had won the state of Ohio, he would have become president, notwithstanding losing the popular vote. And in 2020, if 40,921 votes had come out differently in 3 states, that's less than the number of people who fit into a football stadium, Donald Trump would have become president despite losing the popular vote by 7 million votes. Why is it that it's happened twice in this century and almost 2 other times that the loser of the popular vote became the president when it didn't happen in the 20th century? I don't think it's coincidence. Political scientists have shown that population shifts in the country and partisan shifts that began in the late 1960s make it far more likely today that the loser of the popular vote will win in the Electoral College. And that's likely to continue in presidential election after presidential election. A second flaw in drafting the Constitution that matters today was giving each state 2 senators regardless of size. Again, to be clear, this is a compromise that was essential to having the Constitution accepted in Philadelphia in 1787. The states that were smaller in population did not want a Congress where representation was allocated just on the basis of population. In 1787, the difference between the smallest state, Delaware, and the largest state, Virginia, was 12-1. Today, the difference between the smallest state, Wyoming, and the largest state, California, is 68-1. Let me put this to you in another way. In the last session of Congress, as you know, there were 50 Democratic senators and 50 Republican senators. The 50 Democratic senators represented 42 million more people than the 50 Republican senators represented. And what makes it worse is something that's not in the Constitution, the filibuster. The filibuster can be used for any legislation, in fact, anything in the Senate, except for budget matters or nominations to the federal courts, including the Supreme Court, or to the cabinet. It practically means that in order to get any legislation passed, it takes 60 votes in the Senate. And so senators representing a very small percentage of the country, as small as 20% of the country, can block virtually any congressional action. All of this, of course, contributes to the gridlock that makes it so difficult for Congress to do anything, including passing a budget. And that contributes mightily to the loss of confidence and faith in the government that I described. A third flaw in drafting the Constitution was the way in which it treated race. Alexis de Tocqueville in Democracy in America said that race was the tragic flaw upon which American democracy was founded. And it's reflected in many things in the Constitution. It's reflected in a provision that said that Congress could not ban the importation of individuals for 20 years. In fact, there are only two provisions of the Constitution that can't be changed by amendment. That one and 2 senators per state. Also, at the time the Constitution was ratified, they put a provision into the Constitution, the so-called Fugitive Slave Clause, that said that an enslaved person escaped to a free state, the enslaved person had returned to his or her owner. There's no mention in the preamble of the Constitution, which has such majestic language of equality, equal protection. There's nothing in the 7 articles of the Constitution that were adopted in 1787 that mentions equality, equal protection. That's because slavery was written into the very fabric of the Constitution. A fourth and final flaw that I'd point to from 1787 is how difficult it is to amend the United States Constitution. Article 5, as you know, describes how the Constitution can be amended. It outlines 2 procedures, but only one of them has ever been used. And that requires 2/3 approval of both houses of Congress and then ratification of the amendment by 3/4 of the states. Since 1787, there have only been 27 amendments to the Constitution. 10 of them, as you know, were adopted in 1791. And of the other 17, 2 were to create and then repeal prohibition. So there's really only been 15 other amendments since 1791. The Constitution was written for a very small country, an agrarian country, a country that, as I said, institutionalized slavery, and yet we're living under it today in the modern technological world of the early 21st century. In fact, we now have a court that says that the Constitution should mean the same thing as was adopted for that small agrarian slave society. And it is enormously difficult to change the Constitution. But I think that part of the problems of American democracy come from Supreme Court decisions. That I think the Supreme Court, over the last decade and a half, has contributed to some of the problems that we see that are plaguing our country. Let me give you 3 examples of this. The first is Citizens United versus Federal Election Commission from 2010. There, the Supreme Court held that corporations have the right to spend unlimited amounts of money to get candidates elected or defeated for public office. Now, when you're talking about the presidential election, corporate spending is unlikely to make a difference. The reality is so much is raised, so much is spent. Corporate money isn't what's going to determine the outcome. But when you talk about state and local elections, elections with as much less name visibility, then who spends the most, political scientists have shown, very much likely to determine the outcome of the election. And Citizens United has contributed, in addition to the undermining of legitimacy of government. People perceive, because of unlimited corporate spending, that we have politicians that are just bought and sold by corporations. So an interesting statistic just last week. As you know, the Oakland A's, my now hometown baseball team, want to move to Las Vegas. And they published in the newspaper how many members of the Nevada state legislature received contributions from the Oakland A's. Is anyone surprised? Is anyone surprised that those are the legislators that then voted in favor of a great deal to bring the Oakland A's to Las Vegas? Is it then a surprise to anyone that that contributes to undermining the faith in government? My second example from the Supreme Court is the way that it's weakened the Voting Rights Act. And the case that I would point to here was Shelby County versus Holder in 2013. I regard the Voting Rights Act of 1965 as one of the most important laws adopted in my lifetime. In 1964, in southern states, those that would have comprised the Confederacy, only 43% of eligible Black Americans were registered to vote. In Mississippi in 1964, only 23% of eligible Black individuals were registered to vote. The Voting Rights Act was meant to remedy that, and it did so with remarkable success. A key provision of the Voting Rights Act was Section 5. It says, for jurisdictions that have a history of race discrimination in voting, they would need to get pre-approval, pre-clearance before they change their election systems. Do you remember the arcade game Whack-A-Mole? You knock it down in one place, it pops in another. That's what Congress saw going on, especially in southern states. They would adopt a method of disenfranchising minority voters, only for it to be challenged, either struck down or withdrawn, and then another one, same thing, and then another one. So Congress said, for jurisdictions that had a history of race discrimination voting, they would need to get pre-approval, pre-clearance from the Attorney General before seeing change their election systems. This is remarkably successful. There are well over 200 instances where pre-clearance was denied, and thousands more where the jurisdiction didn't even try to get pre-clearance because they knew that it was denied. The pre-clearance requirements were scheduled to expire in 2007. The Senate voted 98-0 to extend them for 25 years. Can you imagine the current Senate doing anything 98-0? There were only 32 no votes in the House of Representatives. President George W. Bush signed into law the extension for 25 years. But the Supreme Court, on June 25th of 2013, in a 5-4 decision, declared unconstitutional the pre-clearance provisions of the Voting Rights Act. Chief Justice John Roberts wrote for the court. Every year when I teach constitutional law, I ask my students, what constitutional provision or principle was violated by Section 5 of the Voting Rights Act? We're all used to talking about how a Supreme Court decision violates equal protection or denies due process. Well, you have to get to the end of the opinion where Chief Justice Roberts says that it violates the principle of equal state sovereignty, the principle that Congress must treat all states the same. Congress was requiring pre-clearance in only some places. But where in the Constitution does it say anything about equal state sovereignty? I'm not an originalist, but if I were, the same Congress that ratified the 14th Amendment, well, ratified the 15th Amendment a couple years later, voted for the Reconstruction Act and imposed military rule over southern states. What's a clearer indication that Congress didn't intend equal state sovereignty? As soon as the Supreme Court struck down pre-clearance, states like North Carolina and Texas immediately put into effect the very laws where pre-clearance denied because of the discriminatory effect. Now there are studies that show that from 1965, when the Voting Rights Act was adopted, to 2013, without exception, there had been an increase in minority voter participation. It was literally only in one direction. But after Shelby County today, for the first time since 1965, Black voter participation has decreased because laws that are discriminatory can go into effect and have to wait for a challenge, which may or not work. My third and final example of a current Supreme Court decision that contributes to the crisis of democracy concerns partisan gerrymandering. Partisan gerrymandering is where the political party that controls the legislature draws election districts to maximize seats for that party. It's where, say, a Republican-controlled state legislature draws election districts to maximize seats for Republicans. A Democratic-controlled city council draws city council districts to maximize seats for Democrats. It's nothing new in American history. In fact, it takes this name from a governor of Massachusetts from early in American history, Elbridge Gerry, who engaged in the practice. But what's changed is, because of sophisticated computer programs, it's possible to engage in partisan gerrymandering with far more precision than ever before. In 2019, in Rucho versus Common Cause, the Supreme Court said that challenges to partisan gerrymandering are a non-justiciable political question and therefore cannot be heard in federal court. No matter how extreme, no matter how egregious the partisan gerrymandering, there can't be a challenge. And so you can have states where there's sort of a Republican legislature at one point, or Democratic legislature, it can so entrench that party and give it such a disproportionate advantage. Take North Carolina as an example. It's basically a purple state. It went for Obama in 2008, Romney in 2012, and Trump in the last two presidential elections. But Trump beat Biden in 2020 for only 1.35%. And typically, Democrats and Republicans get the same number of votes statewide for congressional seats. But North Carolina was able to engage in gerrymandering, so Republicans would control 10 of 14 seats in Congress. The only exception was that the North Carolina Supreme Court had found partisan gerrymandering violate the state constitution. It created a nonpartisan commission to draw congressional districts. And in the 2022 election, 7 Democrats and 7 Republicans won. The North Carolina Supreme Court has since reversed that, and it's likely in 2024, Republicans will again win 7 seats and Democrats win 4 seats. Justice Kagan in her dissent in Rucho versus Common Cause said, the most basic principle of democracy is that it should be voters who choose their elected officials, whereas with partisan gerrymandering, it's elected officials who choose their voters. This too contributes to cynicism and loss of faith in government. It also contributes to the paralysis that we see in government at all levels. So I've tried to tell you why I see a crisis in democracy. I've tried to say that some of it stems from choices in drafting the Constitution. Some of it is choices the Supreme Court has made. But I want to conclude by saying that there is hope, that all of this can be fixed if there's the will to do it. Almost everything I said can be fixed either by statute or by Supreme Court opinion. Think of the things that I talked about. Now, we can't eliminate the Electoral College by statute, but there could be a major change in the Electoral College by statute, or for that matter, Supreme Court decision, that would matter. And that's to eliminate winner-take-all in the Electoral College. Except for Maine and Nebraska, every other state uses winner-take-all for the Electoral College. So if you live in California in the presidential election and you vote for the Republican candidate, it's as if you didn't vote at all. The Democrat's going to get all the electoral votes from California. By contrast, if you had lived in Texas in 2020 and you voted for Joe Biden, it didn't matter because Donald Trump got all the electoral votes of that state. Maine and Nebraska divide the electoral votes by congressional district. Political scientists have documented that winner-take-all makes it much more likely that the losing candidate in the popular vote can win in the Electoral College. If we eliminated winner-take-all, that would be less likely. Well, states aren't going to eliminate winner-take-all on their own. California isn't going to engage in unilateral disarmament and give some of its electors to Republicans, and Texas isn't going to engage in unilateral disarmament and give some of its electors to Democrats. But Congress has the ability to regulate federal elections, and Congress could eliminate winner-take-all. Or the Supreme Court could find that winner-take-all violates equal protection, and it could find that states have to do proportionate representation. Take the Senate. We can't change 2 senators per state, not by statute, not by constitutional amendment. But the filibuster could be eliminated. The filibuster is not created by the Constitution. It's created by rules of the Senate. In fact, the Senate eliminated the filibuster, first for lower federal court judges and cabinet officials, and then it did so for Supreme Court justices just 7 years ago in 2017. Congress passed a law that allows budget reconciliation matters to be handled without the possibility of filibuster. It would make such a difference in lessening the gridlock in government to eliminate the filibuster. or think of some of the things that the Supreme Court has done. Obviously, the court could, not likely to, overrule Citizens United, Shelby County, Rucho versus Common Cause. But even within the Supreme Court decisions, there can be fixes. With regard to campaign finance, there's so much more that legislatures can do than they've done since 2010. Simple example, legislatures can adopt much stricter disclosure laws with campaign funding, get rid of the dark money in political campaigns that also undermines the legitimacy of government. I believe that legislatures, local, state, and federal, can adopt laws that say that businesses that do business with that level of government can't contribute or spend money for candidates running for that level of government. So a business that contracts with the city of Sacramento shouldn't be able to spend money to elect people to Sacramento's city government. I think that that's a change that could make a difference. Congress can adopt a new Voting Rights Act that fixes the problems that the Supreme Court identified in Shelby County versus Holder. In fact, the John Lewis Voting Rights Act that passed the House of Representatives a couple years ago, only to die in the Senate because of a filibuster, would have reinstituted preclearance and a criteria that would have met what the Supreme Court prescribed in Shelby County versus Holder. Congress could pass a law requiring that every state use independent districting commissions for congressional seats, and states on their own could adopt independent districting commissions for their elections, as California has done. Notice that everything that I've just mentioned can be done without constitutional amendment, simply by statute or change. But there is the possibility of constitutional amendment. I think that we have given up far too quickly on the possibility of trying to amend the Constitution. There's many of the things that I've talked about, such as the decisions about campaign finance, where I think constitutional amendment should be considered. But what if none of this happens? What if we don't see any legislative or judicial fixes? What if there aren't constitutional amendments because they're so difficult to do? What happens then? One possibility is that our country will just drift along. One possibility is that there'll be a turn to authoritarianism. We look at so many countries around the world that were democracies, where autocrats have come to power. I think it's arrogance to believe that there's something about the United States that would provide immunity. Maybe there'll be a movement to break apart the country in some way. Will there be a point where people have to ask, is what unites us as a country greater than what divides us? Now, it could be a secession movement in terms of really separating parts of the country. It could be a devolution of power to the states with a much weaker national government. But all of this, I think, is realistic and possible if we don't solve the problems of American government. Long ago, it was Benjamin Franklin who said, "A republic if you can keep it." And the question that I ask you today is, can we keep it? Thank you.
I'm hoping that Dean Chemerinsky might indulge just a few questions,
Of course.
knowing that he's got a fabulous prize ahead of him. Feel free to walk up to the microphone because this is being recorded. It would be great if you would say it so that the people who are listening online can hear it.
Professor Dean, I have a question about the Second Amendment. How does a well-regulated militia being necessary to the security of a free state translate to individual ownership versus state-issued and regulated arms solely for securing the free state, let alone automatic weapons? You didn't mention the Second Amendment.
Sure.
I'm curious how you consider that in the
Sure.
scheme of our threats to our democracy.
The Second Amendment says, and you quoted part of it, a well-regulated militia being necessary to the security of your state, the right of people to keep and bear arms shall not be infringed. from 1791, when the Second Amendment was ratified, until June 2008, not one federal, state, or local gun regulation was struck down by the Supreme Court. From 1791 to 2008, there were only a handful of Supreme Court cases about the Second Amendment, but always what the Second Amendment said, is implied in your question, is that it's a right to have guns for the purpose of militia service. Then in June 2008, in District of Columbia versus Heller, the Supreme Court said that the Second Amendment protects the right of people to have guns in their home for the sake of security. It involved a 32-year-old DC ordinance that prohibited private ownership or possession of handguns. It was 5-4, Justice Scalia wrote for the court, and he said that the Second Amendment has a prefatory clause and an operative clause. That's his language, I'm quoting. He said the prefatory clause is a well-regulated militia being necessary to the security of a free state. And the operative clause is the right of the people to keep and bear arms shall not be infringed. Now, Justice Stevens in dissent says, it's all operative. Isn't the majority just reading the first half of the Second Amendment out? Isn't the majority just reading the amendment as if it said, the right of the people to keep and bear arms shall not be infringed? The Supreme Court didn't deal with the Second Amendment again until June 23rd of 2022 in New York State Rifle and Pistol Association versus Bruin. It involved a 1907 New York law that said to have a gun in public, you need to have a permit. When you get a permit, you need to show cause. The Supreme Court, 6-3, declared that unconstitutional. Justice Thomas wrote for the court and said that the Second Amendment protects the right of people to have guns in public. He then said that the only type of gun regulations that should be allowed are those that were permitted in 1791 when the amendment was adopted. So the Supreme Court has a case before it now. It was argued on November 7th. The case is United States versus Rahimi. It involves a federal law that makes it a federal crime for a person under a restraining order in a domestic violence case from having a firearm. The United States Court of Appeals for the Fifth Circuit declared that unconstitutional, saying in 1791 there weren't laws that said people under restraining orders in domestic violence cases couldn't have guns. There weren't restraining orders in domestic violence cases in 1791. And it's now before the Supreme Court. And I think it will give us a sense of how far is the court going to go purely on this historical analysis. At the very least, will the court say, in 1791, laws prevented dangerous people from having guns, and that makes this law constitutional. But that's how the court got to the conclusions that it did. And there's only two cases that did this. District of Columbia versus Heller in 2008, the New York State Rifle and Pistol Association Bruin in 2022.
Thanks so much for your remarks today. I'd like to ask you about the very last point that you made.
Right.
You expressed apprehension about the possibility of a turn toward authoritarianism in the United States. One of the questions that, as I know you're aware, has arisen in the scholarly literature is whether our federal system makes such a turn more or less likely, whether the fact in particular that our police and our courts are decentralized makes it less likely that we'll take the path that, for example, Hungary or the Philippines have taken. And I'm wondering what your sense is about that, to what extent our federal system is a bulwark as it was designed to be, or has been weakened in relation to that role.
The honest answer is, I don't know. I don't think any of us can know at this moment in time. There are certainly things that come to mind as I listen to you that should cause us worry. I mean, the Republican National Committee brought Viktor Orban from Hungary and celebrated him and then held an event in Hungary. If this is who they're celebrating, if, I mean, the prior president celebrates Vladimir Putin, shouldn't we be concerned about the turn towards authoritarianism? Then I can come to your question, to what extent is the federalist structure protection? Historically, I think there was much more to fear from state governments than the national government. And the states being closer to the people was something that was more of a danger to equality and liberty. I mean, up until the 1950s and 1960s, every southern state and some parts of northern states had Jim Crow laws that imposed apartheid and separated every aspect of life. And we needed a federal government to come in and end Jim Crow and protect civil rights. There is a much stronger national government now than could have ever been imagined in 1787. That makes sense because the country is so different now. Would a national government be able to come in and use its powers in an authoritarian manner, preempting what state and local governments could do, or just doing on its own? Could a president impose the Insurrection Act, for example, at the federal level to quell dissent? I don't know the answer to your question, but I'm afraid that the ways in which we strengthen the national government to deal with national security issues, to deal with economic issues, could give it the power to be very authoritarian should there be a president of that sort. Imagine a situation where there's a Republican president and a Republican Congress, and imagine the Senate then was willing to eliminate the filibuster. What check realistically exists other than the courts, and how much will they play that role? And that's why I say I don't know. But it's also why I say I'm afraid.
Work my way up here. So thank you so much for being here. I'm Larry Levine. As you probably know, there's a move afoot to call under Article 5 Constitutional Convention, which you noted hasn't happened in history, but some progress is being made, funded by conservative interests, and one of our alums, for better or for worse, is very involved in the effort to make this happen. How worried do you think we should be about this possibility? And if it were to happen, is it an opportunity for us to accomplish some of the sorts of things that you spoke about through a constitutional convention as another option in addition to the things you listed?
And so we don't put this just in an entirely partisan lens. You might know that Governor Gavin Newsom has called for a constitutional convention so as to change the Second Amendment, believing that the usual procedure going through Congress won't do that. I have very mixed feelings on this. On the one hand, I'm worried about a constitutional convention. Who would be the delegates to the Constitutional Convention? Would it be cabined in what it could do? What would be the ratification process? And yet also, I believe that our Constitution should be replaced at some point in time. Just like I said in my first sentence, no democracy lasts forever, nor does it make sense to have a Constitution last forever. And especially if the Constitution is going to be limited to what's thought in 1787 and 1791, doesn't it make sense to consider a new Constitution? In that sense, I think we would need to give a lot of thought to how do we determine who the delegates will be to the Constitutional Convention to make sure that it reflects the diversity of views to the country, and how would we then ratify that Constitution? I will make a radical argument. I think if ever there were a Constitutional Convention, whether or not the new Constitution be approved should be put to a plebiscite, a vote of the people, not using the mechanism of Article 5 requiring approval of 3/4 of the states of what the Constitutional Convention proposes. Because if it takes 3/4 of the states, we're never going to eliminate the Electoral College, because the states that benefit from the Electoral College aren't going to get rid of it. If it requires approval of 3/4 states, we never, even in a new Constitution, get rid of 2 senators per state. Now you say, but the Constitution doesn't provide a mechanism for a national plebiscite. Here history becomes important. Before the Constitution, as you know, there are the Articles of Confederation. Under the Articles of Confederation, it said, it took unanimous approval of the states to change the Articles of Confederation. The Constitution says it only took approval of 3/4 of the states to ratify it. They ignored what the Articles of Confederation said. In fact, at the time George Washington was elected president, neither North Carolina nor Rhode Island had approved the Constitution. And Rhode Island didn't approve the Constitution until George Washington was president for over a year. So I think if we're going to go down the path of a constitutional convention, we should be much more thoughtful and much more willing to consider how it would best be done, rather than feel we've got to follow Article 5 procedures to do it.
Hi, thank you. Well, this has not been uplifting, but
So,
still glad you're here. So my question relates a little bit to the role of the press and the world that we're in right now without a really reliable and ethical, necessarily, press that we can look to and trust. So that's kind of one part that we haven't talked about. And it comes up for me in the context of the disclosure requirements, which you talked about. We can just strengthen disclosure requirements. It's a workaround for Citizens United and lots of other bad election law cases. However, the disclosure requirements rely on the idea that the people will be educated about where the money's coming from and who's getting it. And if you don't have resources devoted to a press corps that is going to do the work to educate the people, and you don't have a population that is willing to be educated and trusting of the facts that they're learning through the news media, what do we do? How does that work?
I agree with everything that you just said. If I had more time, I would have talked about the development of the internet and social media as a threat to democracy. And then I can tie it back to your question about the press. In some ways, the internet and social media are the most important developments for free speech since the invention of the printing press. They've tremendously democratized the ability to reach a mass audience. It used to be in order to reach a large number of people, you had to be rich enough to own a newspaper, get a broadcast license. Now anyone with a smartphone or access to a modem can reach a mass audience instantaneously. If you think of the First Amendment as also about a right to receive information, the internet and social media give us access to infinite information immediately. But I'm very afraid of the effects of false speech over the internet and social media. And that's only going to get worse with deep fakes and AI. There is no doubt that Russia played a role in the outcome of the 2016 election. We'll never know if it was a pivotal role in the election. I worry, in addition to false speech, the extent to which the internet and social media contribute to the polarization that I was talking about at the beginning. There are a lot of studies now that show that people receive their news from things that they already believe in. If you're conservative, you're going to watch Fox News. If you're liberal, you're going to watch MSNBC. And it contributes to the polarization in society. And we don't have a press to perform a checking function. To a large extent, what we get over the internet and social media is just republication of what's already there. There's been, from major newspapers, tremendous decrease in news reporting staffs, foreign bureaus, and the like. You might have read that just this week, the Los Angeles Times cut its news staff by 20% after having last spring cut it by 15%. If you live in San Francisco, I get the San Francisco Chronicle, the New York Times delivered every morning. There isn't much in terms of number of pages to the San Francisco Chronicle anymore. They don't have the staff to perform the checking function of government. If all they're doing is reprinting AP stories, if all Yahoo News is picking up things off the wires, who's going to bear witness? Who's going to do the investigative journalism? And I think that too contributes to the problems of democracy.
Hello, Dean. There was a lot of statistics mentioned at the beginning, including the fact that there's only 20% confidence in government. Justice O'Connor started a program to teach students, particularly middle school students. She was concerned that only 1 in 3 students at that time could mention the 3 branches of government. Now, at the end, you provided the solution that a lot of these issues that were mentioned could be resolved either through statute or through an amendment. Now, what would you propose to be the method by which we educate our population, our students, so that they could become politically engaged and involved in our political process?
I think Justice O'Connor was right. When you mentioned only 1 in 3 could name the 3 branches of government. We have a member of the current United States Senate who didn't know the 3 branches of government when he ran for the office. I saw a poll that more people can name some of the 7 dwarfs than can name Supreme Court justices. And I think we do a poor job of civic education in the United States. I regularly have taught undergraduates as well as law students, and I'm surprised by even those who have gone through school in the United States and should have had United States history, their lack of knowledge and understanding with regard to basic constitutional principles. I'll tell a story from my students. One of my faculty members wrote an op-ed in the Wall Street Journal that they really disliked. So the day it came out, the 2 co-presidents of student government, and this is at Berkeley Law, came and said, how could you let him publish that? And of course the answer is, how could I stop him? There's no prior restraints allowed. He's got freedom of speech. I would hope that law students would recognize this. My guess is their emotions, why they said that, but I do think we do a poor job of civic education. I don't have the answer to your question. I wish our society would invest far more in K-12 education generally as it did. I wish that programs like the one Justice O'Connor created for civic education would reach much larger numbers of people. And to the extent the theme of my talk to you today is about democracy being in danger, if people don't understand democracy, how are they going to believe in it? And if they don't understand or believe in it, how can it survive?
Try not to waste too much time getting to the mic here. Okay.
Nice to see you again.
Good to see you again. We first met way back in college. We debated against each other. And I should defend Justice Kennedy's decision in Citizens United. What the heck, you know? And let me put to you a thesis, and you can respond to it, which is that the problem is not Citizens United, it's Berkeley. Because if you simply cut off corporate spending, the money just comes out of a different pocket.
Oh, I agree. Let me qualify a little bit. They're both a problem. It was Buckley versus Vallejo in 1976 that said that spending money in election campaigns is speech. I think that was wrong. I think spending money is conduct that communicates. I think the court was taking a figurative expression. Money talks far too literally. And I think the court compounded that by saying, in Bellotti versus First National Bank of Boston, that corporations have the same rights under the First Amendment as individuals, and developed arguments against that as well. Citizens United builds on Buckley and builds on Bellotti, but it also does something that in itself is pernicious. In prior cases, the Supreme Court said that the government can restrict expenditures so as to keep some voices from drowning out others. As you know, in Austin versus Michigan Chamber of Commerce, in McConnell versus Federal Election Commission, the Supreme Court had said that. But Citizens United overrules McConnell in Austin. It does so explicitly. In fact, the very provisions of the Bipartisan Campaign Finance Reform Act that Citizens United declares unconstitutional, 7 years earlier in McConnell versus FEC, the Supreme Court had upheld. So I can agree with you, but I also think that all of these decisions have had a very corrosive effect on government and had a corrosive effect on people's trust in government.
We'll conclude the final question from the Anthony M. Kennedy chair at McGeorge.
Here we go. My question relates to your comments about the filibuster.
Right.
And for people who may not know about the filibuster, it's a Senate rule that for many, many decades, and actually still with respect to legislation, requires a 60 senator vote out of 100 to achieve a result as opposed to a mere majority. And so you're critical of the filibuster with respect to legislation. And you say that it's undemocratic and leading to undemocratic results because of single senators or being able to hold things up. But I have to say that after what's been going on with
the composition of the Supreme Court in particular, and what I view as the manipulation of the rules in the Senate, and then the closely divided Senate, and the ability to essentially ram through justices when it's very closely divided, when you only need a 51 vote. I find myself yearning for the filibuster with respect to judges. And I have been thinking about it, thinking that it would lead to compromise and lead us to have more justices who better represented the population in that way. And so I wonder your thoughts about that.
Sure. Let me say two things. One, which I didn't talk about, is how the filibuster changed, which has made it much more pernicious. I don't know how many of you ever saw the movie Mr. Smith Goes to Washington. And if you haven't seen it, I recommend it to you. It's an older movie by Frank Capra with Jimmy Stewart. And it's wonderful about Jimmy Stewart being a senator fighting against corruption. And he holds a filibuster requiring him to stand at the lectern until literally he collapses and shames the other side into submission. Well, Congress changed the filibuster in the 1970s, so no longer does the filibuster require that anyone stand at the podium. Because they wanted to make Senate more efficient, all the senator has to do is say that I'm going to filibuster, and it takes 60 votes for cloture. Other changes have made it so easy to engage in the filibuster, which I think contributes to the paralysis of government, how difficult it is to get Congress to do anything, and that contributes to loss of faith. What you described has appealed to me, that if we had the filibuster for judges, then couldn't it be a situation where in order to get a judge, you'd need a compromise, and then that would give us more moderate judges. And we might not get a Sonia Sotomayor, but we wouldn't end up with Neil Gorsuch either, and because we'd have that. If it worked that way, I think I'd be persuaded. I'm afraid of the opposite. I'm afraid that it would increase paralysis, and instead of the filibuster leading to compromise, it would just make it easy to block anyone from being confirmed. And what basis do I have for that? Think about what happened in 2016. On February 13th, Antonin Scalia died. In March, President Obama named Merrick Garland Chief Judge of the United States Court of Appeals of the District of Columbia Circuit to be a Supreme Court Justice. Impeccably qualified, longer tenure as a federal court of appeals judge than anybody else who'd ever been nominated for the Supreme Court. Garland was moderate. In fact, a very liberal Ninth Circuit judge yelled at me for supporting Garland's confirmation, saying he's not liberal enough. What did the Senate do? They held no hearings, no vote. Garland, of course, never got considered, never confirmed for the Supreme Court. I think if you create the filibuster for judicial nominations, it'll be easier for the minority party to block anybody. Not to enter into a compromise, as you say, just to block anyone from getting confirmed. I think we're now at the moment in time where when the president is of one political party and the Senate is of another political party, no one's going to get confirmed for the United States Supreme Court. I think that the Republicans have set a precedent that both parties will use in that regard. I think the filibuster would then make it possible for the minority party not to enter into a compromise, but to completely block confirmation. And that's what scares me about it. Thank you again so much for coming and for having me.
Thank you so much, Dean. No one should leave McGeorge without a ridiculous quantity of McGeorge stuff. And so we found the largest bag possible of McGeorge stuff to give you as a thank you.
Thank you. That's so kind of you.
Thank you all for being here. Please make it to our next events. We're really excited by the lineup of speakers and activities coming up in the coming months. I really appreciate you all being here. The next event will be the Ninth Circuit holding oral arguments right here, followed by a conversation on civility in cooperation with the California Judges Association. Thank you for being here tonight.